Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. This is another episode in our series entitled Buying Tenant-Occupied Property in a Just Cause State. And the subject matter expert is here with me, Kaitlyn Jackson, lawyer with Williams Kastner in Seattle. Kaitlyn, tell us about your practice.
Since 2018, I've been practicing landlord-tenant law, and I do a lot of transactional work of properties that are purchased or sold that are tenant-occupied.
Okay, I'm going to create a scenario, and you tell me if this has ever happened. Seller gives notice. Let's say seller gives. Let's say the state law is the controlling authority in the jurisdiction where this property is located. And so seller gives 90 days notice on January 1st to their residential tenant, single-family residential tenant, to vacate the property at the end of those 90 days. So that'd be January, February, March. At the end of March, tenant vacate the property because I'm selling the property. Tenant gets that notice, and listing broker says, awesome, that notice has been delivered. Let's get the property on the market. So middle of January, that property goes on the market, sells pretty quickly, and we have a closing on March 1st. Buyer's pretty excited because they know that tenant now has to be out in 30 days, at the end of March at least. That would be when the tenant was supposed to move out. So buyer, now new landlord, is waiting for the tenant to move out, and on April 1st, they're not gone. So buyer landlord calls their lawyer. Lawyer says, let's evict them. They start the unlawful detainer action. Kaitlyn, what happens?
That case will likely be dismissed because the buyer is not the entity or person that submitted the notice to begin with that said, your tenancy is being terminated because I, landlord and owner, am selling the property. Now, the standing of that person to bring that action is no longer available. They are not the previous landlord. They are not selling the property. They've bought the property. So that notice is no longer good.
You've said this in a prior episode in this series, but here's what I think will happen based on what you've already taught me. We're going to get through those 90 days. So now it's going to be April 1st before I, as the buyer, can call my lawyer and say, hey, the tenant was supposed to have moved out into March. They didn't move out. It's going to take me a couple weeks probably to get into my lawyer's office or to really get things moving. And then if my lawyer starts the unlawful detainer action for me, you've already told us that in some counties, we're 7 months out before we even get in front of the judge.
Yeah, that's pretty much just King County. But yeah, and that's a big county.
Okay. Or in other counties, it's probably still at least a couple months in most cases, isn't it?
Yeah, I would say if I'm going to give somebody an average ballpark statewide, you're looking at a hearing date that's 7 or 8 weeks out. And it might be that a first hearing date is set up for the first hearing, but there's almost always at least one continuance given the right to counsel in the state of Washington.
So let's just play out these dates. Let's say that I got in to see my lawyer on April 15th. By the time I had talked to the tenant says, I'm not moving out, and I made an appointment with my lawyer, and I actually got in to see him. Let's say it's April 15th now. And I've owned this property since March 1st. Now it's April 15th. I go see my lawyer, and my lawyer says, well, let's get this unlawful detainer action started. And unless we're in King County, let's just say it's going to take May. So by the middle of June, early to mid-June, we're in front of a judge, right?
Mm-hmm. A commissioner.
And that commissioner is not going to say to the tenant, get out. The commissioner is going to say what to me, the new owner of the property?
Well, what is your good cause for terminating this tenancy? I understand the previous owner had good cause. They were selling the property, but they've already sold it. So what's your reason?
I want to move in.
Okay, well, then you needed to serve a notice that said that you were going to move into the property, and that's another 90 days.
So now in the middle of June, I'm not able to remove the tenant. Instead, I'm at the very beginning of this process, delivering a brand new 90-day notice. So now we've got to the middle of July, August, middle of September. Then we can start the unlawful detainer action again. Maybe I'm in by Thanksgiving.
Maybe, and that also depends on where the property is located and if there aren't any local ordinances that actually put additional restrictions or barriers on terminating a tenancy or removing a tenant during certain timelines. So an example of that, I think Seattle, we have our winter eviction ban. Tacoma, we have our winter eviction ban. We have our school year eviction ban in Seattle and in Tacoma. Now, if an owner has served a 90-day notice of intent to personally occupy, that may be exceptions to those protections.
In some cases,
but it might not. They could change that at any time. And so those are the types of things that have to be thought about, looked at, analyzed, usually by an attorney.
Takeaway, brokers, if the seller has delivered the notice intending to terminate a tenancy in a single-family residential property, do not let the transaction close for a buyer to purchase that property. If the buyer is expecting that tenant to be gone based on the seller's delivery of the notice, do not let that transaction close until the tenant is gone, right?
Well, I'll add a piece to that is what I have seen done is as the seller, you're never quite sure how quick is this property going to fly off the market? Is it going to take me all 3 months to get a seller that gives me the price that I want? The buyer, the price that I want, or is this property going to fly off the market in a week after I've served my notice? And so what I have done in that circumstance is issue a new notice upon closing to the tenant. That's the property actually already sold. The new buyer wants to move in, right? And so then you can start that clock on that 90 days a little bit earlier than just waiting until the original 90-day expires. That's possible. You can do that.
But with that, the new buyer takes the property subject to that existing tenancy and starts their own 90-day notice.
Correct.
Now, if that tenant doesn't move out, they've got to go through the unlawful detainer.
That is correct.
So buyer brokers, bottom line is if your buyer wants the property tenant-free, don't close the transaction until the tenant is not only the 90 days have run, but the tenant is out, right?
Right. Yes, I believe that is the most sure way where people are carving out liability that they could put on themselves or their license. An example that I've seen is where the seller obviously has the right to terminate because they intend to sell. The conversations between the parties are that, I've sent my notice to terminate. It's terminated by the end of March, just like we talked about. But what is never asked is whether the buyer is actually intending to personally occupy, because sometimes it's a cash sale where that conversation isn't really relevant because the lender isn't involved. And so then the buyer steps in and then they realize they actually have no cause to terminate because they never intended to personally occupy or have a family member personally occupy. Now that has exposed some of those brokers in that situation for not having that nuance present when they're negotiating that deal as part of that deal.
So again, that follows on the heels of the tenant not being out by closing.
That's right.
Brokers, takeaway. I said a minute ago, do not let that transaction close. Now, we all know you don't have control over whether or not a transaction closes. A transaction closes based on a contract requirement, contract timeline. So here's a better way of saying that. If your buyer wants to write an agreement with a closing that will occur before the tenant is out of the property, or right on that 90-day timeline where if the tenant doesn't move at the end of their 90 days and an unlawful detainer action is required, there may not be time to allow that unlawful detainer action to go forward. You will need in that agreement some language that gives the buyer the contractual right to extend the closing date based on the landlord's obligation, the landlord-seller's obligation to remove that tenant. You cannot draft that language. So brokers, if you have a buyer purchasing tenant-occupied property with the intent that that tenant will not be in the property by the time the buyer takes ownership of the property, that buyer needs to go talk to a lawyer. You should not draft the provisions around the concept of ensuring that the tenant is out of the property prior to closing, right?
Right. Correct.
This is going to be a complicated provision. And the best thing that your buyer can do is just push off closing, push off that agreement. But I understand that's not possible in some circumstances. They want to lock up the property. But how do they guarantee for themselves that they don't inherit the seller's property of a tenant who won't move? They need to talk to their own lawyer about that. Their lawyer is licensed and insured to give them the advice they need on that topic, and you are not. If you have questions on anything we've talked about in this episode or anything else, ask me a question by visiting WARealtor.org. Thank you for being a Washington REALTORS member.